The Department of Justice is set to formally appeal that decision by a Trump-appointed federal judge to appoint a so-called special master to review the documents seized by the FBI from Mar-a-Lago and to essentially order the DOJ to stop its investigation into Trump using the documents they recovered for the time being. In a legal filing, DOJ argues, quote, the government and the public are irreparably injured when a criminal investigation of matters involving risks to national security is enjoined. Prosecutors also appear to believe that Trump may still unlawfully possess some classified records they have not yet seized. Quote, the injunction against using classified records in the criminal investigation could impede efforts to identify the existence of any additional classified records that are not being properly stored, which itself presents the potential for ongoing risks to national security. Lots of questions about what all this means to the investigation going forward. To help answer them, I'm joined by Mary McCord, former acting assistant attorney general for national security at the Department of Justice. She spent nearly 20 years as an assistant U.S. attorney in Washington, D.C., now a visiting professor of law at Georgetown. Mary, great to have you on the program. I know this is kind of an area that you practiced in. First, I guess if you could tell us, what is DOJ asking for here? Because they haven't quite appealed yet, right? They're sort of asking Judge Cannon to reconsider, to change along relatively narrow grounds. What do they want?
So they have noticed an appeal, right? So they've actually filed what they are noting an appeal, but they're asking to only stay a portion of the district court's ruling. So I think this is actually a very legally sound move and strategically brilliant move by the department, because what they're doing is they're asking Judge Cannon to stay that part of her ruling that they have the best likelihood of success on appeal. That is that part of her ruling that says you can't use any of the materials. They're just asking for the stay on the prohibition on using classified materials in their investigation, and the requirement to actually turn classified information over to a special master who, of course, has no real authority to review, no need to know classified information. So what they're doing here is saying, we'll go ahead, we'll comply with the special master even during the pendency of our appeal with respect to all of the unclassified and personal documents. In fact, we're just going to hand those all over to Mr. Trump's attorneys. They can review them themselves. They can claim attorney-client privilege and executive privilege if they want. But we want you, Judge Cannon, to let us go ahead and use the classified. And if you don't let us do that by next week, we'll appeal that up to the 11th Circuit and ask the 11th Circuit to allow us to move forward using the classified information.
Right. They're basically saying, look, there's 100 of these classified documents. They're the heart of the whole matter. They're the heart of the risk and damage assessment, the heart of the criminal case that we're investigating. All the other documents, like, fine, do whatever, knock yourself out. But there's no reason that we should have to hand over these 100 classified documents to who? The person who hasn't even been appointed yet, who likely finding someone with that level of clearance itself is going to be a pain.
Finding someone with the level of clearance would be a pain. And I think importantly, if you think about the classified information, most of these are likely original intelligence products by the intelligence community. So what DOJ is saying is that necessarily, number one, these are not Trump's. They're not his personal records. He has no entitlement to them. Number two, necessarily, they can't include attorney-client privilege information or be executive privilege information because they're classified documents and there are no handwritings on them. So, I think they're actually making it easy for the district court judge to do the right thing here, and I hope she'll do that.
It's funny you said that, because I read the filing as a kind of off-ramp given to Judge Cannon after what many people thought was a truly strikingly some would say lawless ruling or creative ruling that enjoined criminal investigation, that conjured the notion of attorney-client and privilege in documents of which there was no reason to believe there were any. Donald Trump doesn't have an attorney-client privilege because the CIA produced some doc that he's got shoved in his basement at Mar-a-Lago.
Yeah, that's right. And so I think that's why I say this was a legally sound, but also I think really good strategic move on the part of the department. And, I think, we'll see what the Judge Cannon does. But I think if she does not grant this stay, I think they have put themselves in a very good position with the Court of Appeals, because essentially the Court of Appeals would have to, reject the notion that these sensitive national security documents up to top secret and beyond, sensitive compartmented information, are not so significant to our national security that they should have to go through this special master process. And I just don't see the 11th Circuit doing that, notwithstanding the composition of that circuit.
Yeah, which is a very conservative circuit, we should note, has a lot of Republican appointees and is noted as a conservative circuit. But this is a narrow appeal that they have noticed. Mary McCord, that was really great. Thank you very much.